Okay, welcome back, everybody. Today we are honored with more legal eagles. It seems as if the flock is growing. We've got not only Max Rossle, whom you know by now, but we're also honored to have Francois de Kock um, from Francois de Kock Attorneys in the chat today, who is going to assist us um, in unpacking this matter. All the questions that we have when it comes to when can I actually use my firearm in self-defense? So what I'm going to do is I'm going to hand over to Max to just give us a bit of an intro on Francois, and then Francois can take it from there if that's fine.
Perfect. Thank you, Dion. Dion, thank you first of all again for hosting this series. I think it's of immense value to people that are interested within the legal sphere of firearm ownership, which is actually one of the biggest spheres of firearm ownership and responsible firearm ownership. And I'm very, very pleased to introduce Francois de Kock to you today, Francois de Kock Attorneys. Francois is a university friend of mine who grew into a formidable legal practitioner. I'm very proud to be associated with legal minds and academic minds of his caliber. And Francois is a criminal practitioner, and I'd also coin him as a Firearms Control Act expert with very deep insight into where, let's say, lawful firearm ownership meets potential criminal challenges as a criminal law practitioner, which Francois is, and having actual groundwork and not just academic knowledge of the concept, but also practical knowledge in dealing with the potential or the use of potentially lethal force in deterring or stopping attacks. Typically, we hope the attacks are unlawful, and that's the big caveat here. So I think that it's easiest for me to allow Francois to just introduce himself. But again, if there's personally, if there were to be a life-threatening situation in which I would have to discharge my firearm or where it's necessitated, my first point of call has and for some time being and will for some foreseeable time be Francois de Kock. So yeah, Francois, please give us some insight into yourself, your practice, who you are, and yeah, we'll take it from there.
Hi, gentlemen. Thanks very much for having me, and thanks, Max, for the flattering introduction. Yes, I practice under my own name for my own account in Brooklyn, in Pretoria, and I have been a practicing attorney for about 10 years, and about 6 of that I've been practicing under my own name. I specialize in criminal law and in firearms law, so all the various aspects of criminal litigation and investigations related to that. And then as far as firearms law goes, that obviously has the let's say the shooting incident component and also the licensing and all the compliance aspects of the Firearms Control Act. And of course, those two specialties of mine overlap to a certain extent as well. I previously worked for attorney Mr. John Kotze, who is a senior attorney and well recognized over the country as a firearms law and also a criminal law expert. And with me, my consultant that works with me is called Jodie Meyer. She specializes in criminal work specifically. She is also a former public prosecutor. So I think we are well suited to your firearms or criminal law needs, especially as far as, let's say, shooting incidents and defensive shooting incidents go. And I look forward to discussing with you guys all the aspects relating to that. I practice specifically in Pretoria, but I go wherever a client requires me to go. So I look forward to hopefully contributing some valuable insights into the discussion today. Thanks.
Excellent. Thanks, guys. Thank you, Max. Thank you, Francois, and welcome. Before we jump into it, just remember that this is a legal discussion. This is not to be taken as legal advice. Remember our disclaimer, which we will pop up on the screen and all over so that you remember it when you sleep. um, So please test whatever we say against your own legal counsel to make sure that we are not giving you the wrong info. We've discussed over the previous episodes, we've discussed all the ins and outs and whereabouts of competency, and then the licensing process, under which sections you can actually license which type of firearms, and so on and so forth. So now you've finally you have your firearm which is licensed in your name, and you've done one or two courses with one or two of the suppliers or the trainer institutes in South Africa. And now the unthinkable or the worst scenario unfolds. You now had to discharge your firearm in a defensive situation. And the question then, what now? What do I do once I've discharged my firearm in a defensive situation? So what we're going to do is we're going to open the discussion to become a general discussion with Max and Francois leading it. And we will discuss all the ins and outs regarding this general scenario. So, gentlemen, I have now discharged my firearm in a defensive situation, what I deem to be a defensive situation. What do I do next? What is my next move?
So I think just to also clarify that there will always be preconceived ideas of where the firearm will be discharged. And I think that potentially the protocol might be different in a public setting versus a private homestead setting. So I think given that, Francois, I'm calling you if I discharge my firearm. So I think you should take it away from there.
Thanks, Max. Yes, I think to just set the scene, it's impossible to predict, I guess, where exactly one would find oneself in such a situation. And obviously, it's something that typically occurs in seconds, not even minutes. So I think one should expect from the outset that there will be quite a very dynamic environment in which you will find yourself. That environment will involve probably lots of, whether it be eyewitnesses or just curious onlookers. It will likely involve ambulances. It will most probably involve the police, etc. So it is something that must be taken very seriously, and the way that you act on that on the scene, if I can put it that way, might very well be what makes the difference between you not even being charged on the one extreme, or being sentenced to prison for a very long time on the other extreme. It obviously depends on various factors, but that's the significance of the right versus the wrong conduct in that scenario, and that will determine whether or not you might be arrested at the scene or not, whether your firearm is seized or not. There's also obviously the possibility of civil claims. And of course, criminal prosecution remains, I guess, your main concern. And not to mention the fact that in this scenario, let's assume you have caused the death of another person, whether it be lawful or not, but it's quite the significant occurrence. So I think what I want to say at the outset is that our law provides that if any person is killed or dies due to an unnatural cause, then one of two things must happen. There must either be an inquest, what we call in Afrikaans a geregtelike doodsondersoek, which is a legal process whereby the court must determine what caused the death of this person and certain other aspects, and whether or not somebody is criminally liable. Alternatively, somebody has to be charged. If there's not an inquest held, somebody might be charged outright with a certain offense, whether it be murder, culpable homicide, assault with intent to do grievous bodily harm. It all depends on the circumstances. Obviously, a murder or culpable homicide will be the two possibilities in the event that this person that you have shot has passed away. Now, I think just to run through a few, I think, practical points that you can try and memorize and try and use if you're in such a scenario. The first thing I would say is don't leave the scene. Regardless of what happened at the scene, the moment that you leave the scene, people start inferring or inferring that you are guilty, or you end up with a situation where you have to explain many months later in court why you did not stay on the scene and why you chose to abandon it. That's the first thing. The second thing is the moment you leave the scene, you lose complete control over what occurs there after the shooting. And that, like I said, is going to be crucial in determining what happens to you at the end of the day. So in as far as it is safe, do not leave the scene. It's debatable when it won't be safe. I guess if you've shot someone, but the threat of being attacked by others still persists, and you see the possibility or the opportunity to get away from that, that would be practically and legally a good idea typically. In other instances, you might shoot the perpetrator, but it becomes a very hostile scene as far as the way that bystanders might react. But as that's a call you have to make in the circumstances. But as far as it is at all safe, do not leave the scene. That's the first thing, because you're going to have to do a lot of important stuff on the scene. The second thing is,
Francois, before moving on to the second thing, and it's just something that I think that lay people just need reminding of. In as far as conduct is concerned, it must always be within the realm of reason or reasonable conduct in decision making. That if the reasonable person were to stay or hang around, would the reasonable person assume or that there would be further harm, or if there are threats or further threats or that kind of thing, given the environment? So you discharge a firearm in a public setting, and it becomes a volatile or an aggressive situation towards you, and your personal safety is at stake due to how the public has reacted, or how a third party has reacted, or whatever the position is. Potentially, the bad guys are still there, and there are more bad guys, or that kind of thing. So the bad guy number one is dead, but 2 and 3, or rather, bad guy number one is incapacitated, but bad guys 2 and 3. That's the dynamic of the situation. But reasonably, your conduct must always be within the ambit of reason. And another point now, just before it slips my mind, Francois and Dion, we co-authored a very brief, Francois and I co-authored a very brief written article on self-defense considerations, which would typically apply to a more private homestead setting or self-defense setting. And I think we can share that article in the links or in the written format for people to follow and just read. And I think that if you are listening to the show, try keep a checklist, a number checklist or point form checklist as we go along, or as Francois introduces the topics as we go along, because it is of immense practical value, and potentially keep it at a place that's simple for you to digest or follow after something like as a phone note, or as a something on the fridge or something like that the rest of the family can also follow protocol. So thanks, Francois. Sorry, I just wanted to add to that.
Sure. No, thank you, Max.
Point one, don't run away unless you really have to.
Yes, I think let's conclude step number one by saying that have a good explanation as to why you left the scene. There might be a very good explanation that is completely reasonable, but it might be that you cannot answer the question later on as to why you ran away, number one. And number two, you are missing out on a lot of important things by not being on the scene, where people are going to be asking questions until kingdom come from you as to what happened there. So point one is remain on the scene if at all possible. Step number two, don't tamper with anything on the scene. Perhaps it's a good idea to tamper if you committed murder and you know that you have zero chances of succeeding in private defense, but still my advice would not be to tamper with the scene.
Okay, no, this isn't legal advice.
Do not tamper with the scene, because the fact is, the more you tamper with the scene, the more difficult it will likely become to prove your version afterwards, and you're going to have to adapt your version in accordance with the facts as they evolve. And at the end of the day, there's nothing that makes you look more guilty than having tampered with the scene, where you later on then say, no, but I have a perfectly reasonable explanation as to why I shot this person, but then why did you choose to try and affect the scenario afterwards if it was clear-cut self-defense. So I know that these situations are dynamic, and it might be that in the moment you are not quite sure whether you have acted in such a way that a proper case could be made out for private defense. But believe me, you are only moving backwards and digging the hole deeper by tampering with the scene. I never say never, but I've almost never seen an instance where anybody helped themselves by doing that, as opposed to creating problems for themselves. So that would be the number two: do not tamper with the scene.
On that point, Francois, tampering with the scene. Let's say the perpetrator is armed. Again, I don't like to go into hypotheticals, but it's the first question that comes to mind. You know, in the hypothetical situation that we all play out in the back of our minds. Everybody has their vision of how it's going to happen and you know, when and where. But what it comes down to is if the perpetrator drops a firearm or drops a sharp object or the blunt object or whichever object, or potentially, you know, let's just focus on objects or life-threatening objects, which was used in the perpetration of the unlawful attack to which he reacted, putatively or rightfully so. With that incapacitation, or let's say that firearm is dropped, or the person is still holding the firearm. What is your practical advice in those circumstances? If it's still prevalent, or the person drops it and runs away, you know, those are important considerations, because typically one of those three things is going to happen. He's going to retain physical control of that firearm or object. He's going to drop it next to him in an incapacitated state, or thirdly, he's going to drop the voorwerp or the item, and he's going to leave the scene. Or, you know, so that's just something from a practical perspective, without getting too deep into the FAQs. That I'd
No,
just like you to address.
I think we must just be careful here that we don't, you know, start painting all these hypothetical scenarios, because that's going to be a lot to answer.
It's that fine line between tampering, you know, with evidence. So is it tampering if it's been dropped in a certain point and I move it away from him, or
no? I would just summarize it to say that you need to have a reasonable explanation as to why you let's call it tampered or interfered with any of that. I think it might be very well a good idea to, you know, physically remove the firearm from the attacker's hands if you doubt whether he's completely incapacitated or not. It might pose a danger to others on the scene that might want to pick it up or something like that. But the best thing you can do, if it's at all safe, is leave it exactly where it is. Because there will be police sketch artists, and there will be photo albums, and there will be reconstructions, etc. All right. So then point number 3, I think, is to report the incident as soon as possible. So in other words, you don't leave the scene, you don't tamper with anything. And now at the first reasonable opportunity that you have, once you're sure that you've gathered yourself and, you know, your family or whomever on the scene is safe, you contact the police. If the perpetrator does not seem to be deceased, I would suggest you firstly contact the ambulance. The fact that this person might or might not be a criminal, and if it's a lawful self-defense, clearly that person was in the wrong and you were entitled to take the necessary action, and this action has now resulted in this person's death. But if you can avoid that, if you can avoid a person passing away, whether that person is you know, the worst criminal in the world or not, you most definitely want to do that, because that has a huge impact, I think, on the trauma that you need to live with afterwards. It has a huge impact on the nature of the legal proceedings that might follow, etc. So if you think it's going to be of any value, phone the ambulance first. If not, phone the police first. The question now comes up of when you phone your lawyer. We'll get to that in a moment. The step of phoning your lawyer doesn't necessarily come in at one specific point, but do accept that if you phone your lawyer before you phone the police or the ambulance, the question is going to be asked as to why did you first phone your lawyer? And you might have a reasonable explanation to say that I was so overwhelmed, I didn't know what to do. I phoned him, he said to me to phone the police, and then 2 minutes later I phoned the police. But I would if circumstances allow, I would suggest you first phone the police or an ambulance, depending on the situation. Now, as far as what you do in this phone call, I think at the outset you want to point out very clearly and very concisely that there's been a shooting and you have been the victim. All right. So that's the opening line. You want to communicate that somebody has been shot, and you want to communicate that you are the victim of this shooting, and you keep it brief, you keep it simple. There's no keep in mind these calls might very well be recorded. So I would give a brief description. I would explain that I'm the victim, and I would then explain where I am and leave it at that. Now, if the police or the ambulance is then being dispatched, that might be a very good time to phone your lawyer just for some practical advice, or to make him more aware of the fact that this has now occurred, because there might now be a large a risk that you will get arrested. All right. Now, as soon as the police arrive or an ambulance arrives or whomever arrives, some onlooker or somebody who saw the whole incident or somebody that arrives after the fact, I think it's very important to control the narrative and to make it clear that you were a victim. The circumstances will dictate, but the thing is, if people are standing by, you would want to point out to them, look, he had a firearm, and look, this is where he stabbed me, or whatever the case might be. So you need to set the scene as far as possible, and obviously as far as it is reasonable. It's no use to try to convince people of one thing while they saw with their own eyes something else happening. But as far as it is helpful to the scenario, you want to control the narrative, you want to point out that you are the victim, and when the police arrive, you want them to understand also that you are a victim, and you need to give them a brief description of what happened. Now, this is a bit of a fine balance, because on the one hand, you don't want to say too much. On the other hand, you don't want to say too little, but you must understand that a police officer has now arrived on the scene. He doesn't know who's who, and he might have certain prejudices, or he might not. But the fact is, you can't always expect him to just assume that you are Mr. Lawful Firearm Owner, responsible citizen, and the person that you have shot is Mr. Evil Attacker of innocent women and children, if you know what I mean. So it is important to at least give a brief description. If you know that you are going to incriminate yourself by even giving the most basic facts, well, then I would rather say, I don't want to do so. But you cannot expect that person to be accommodating to you if you don't at least give him some basic facts and a basic description. So that is, in short, step 4 is to set the scene, control the narrative, and give a brief description to enable the police to follow up what is happening on the scene. Then the next step, let's call that number 5. I would say that you intend to cooperate. You make it very clear to the police that you will cooperate. And depending on the scenario and your own judgment, it might not be the worst idea to give them quite a description of what exactly happened, to answer some basic questions. But as soon as it gets to the point of very specific questions, or it gets to the point of contentious questions, or questions that seem like cross-examination, or if they want you to record a statement on the scene, I would most definitely suggest that you say politely, I do intend to cooperate. I'm going to phone my attorney now, or I've already phoned him. I will in due course provide a detailed statement. Here's my contact details. Here's my residential address. But I'm in shock at the moment, and I don't want to, commit to a very specific version at that point in time. So you have to play it by ear, but don't go too far. Keep it basic. Promise cooperation. Answer basic questions. Do not answer to cross-examination. Do not make a statement. Do not sign any documentation on the scene, even if you are convinced that is correct. I often see scenarios where a client explains something to me, even a day or two after it happened, while he's had time to let's say regurgitate it and think about it. And then afterwards, facts emerge to show that even though the client was completely in the right, he was mistaken regarding various aspects that actually happened, or he recalled certain aspects incorrectly as a result of the shock, or whatever it might be. So be very careful to formally commit yourself to a certain version of events, because you might not be convinced as you think you are. Now, the next...
Can I just ask something? Sorry, Francois. For me, as the victim on the scene now, how do I know that what I'm saying to this policeman, when does it become a statement? or when is it just me relating info?
So the police take down written statements, whether it be in the form of a warning statement, which is a statement that is deposed to by a suspect, and the police call it a warning statement. And this statement can take more than one form. The police typically use a pro forma document, and they ask you certain questions, inform you of certain facts regarding who they are, what they are investigating. They warn you that you have a right against self-incrimination and that whatever evidence you give might be used against you later, etc. That's why we call it a warning statement. And then they can either ask you specific questions and record specific answers as far as what actually happened during the incident, or they can ask you to make a statement. In practice, typically the police take the statement down on your behalf. And I'm glad you raised that question, because when it gets to the point of making a statement, I would first of all suggest being legally represented. But in any circumstances where you give a statement, the police typically take it down. There's typically a language barrier between the two of you. They are, depending on the circumstances, not necessarily extremely literate, or their ability to write a proper statement is not necessarily up to scratch. So I would suggest that if you write a statement, you write your own statement, but I would rather suggest that you just have an attorney assist you. But if you were ever to give any statement on the scene or on a scene, you might just be a eyewitness to what happened, and nobody's looking at you, and you simply explaining to the police what happened, and they want a short statement, and you consider yourself able and willing to do it. I would still suggest that you rather write your own statement, and because then you emphasize what you consider necessary, as opposed to the police officer taking down the statement and making you sign it. But just to get back to your exact question, the statements that you make to a police officer or to anyone on the scene can, in theory, be admissible as evidence against you. If it's another person relaying it to a court or under oath, it might be considered hearsay, but there are certain exceptions to the hearsay rule, and there are ways that hearsay evidence is still admissible. Our statutory law regarding the law of evidence makes specific provision as to how and when hearsay is permissible. So except that what you say there, even though it's not a statement, it's just a comment or a question answered, it might be recorded even, because you are entitled in South Africa to record any conversation to which you are a party, and provided you want to use it for a lawful purpose. So keep in mind that somebody might record you. They might attempt to later testify that you said this or that or the following, and then it becomes a question of admissibility based on the hearsay rule. Typically, police don't record you. Typically, they ask you questions to try and figure out what's going on, and typically they take down statements, and the case ends up being about what's in the case docket, the statements, and the prosecutor decides based on that whether or not to prosecute you. But the thing is, once this matter goes to court and people start testifying and they start being asked a lot of specific questions or cross-examined, that's when suddenly things come up like, yes, he said this to me at the scene, or he said that, or he did that, stuff that might not appear in the, let's say, the formal statements that are taken down later. So to answer your question, whatever you say, whether it's in a friendly manner where the investigating officer has just shaken your hand and said, I can see you are the innocent guy here, and thanks for taking the criminal off the streets, or how friendly it might seem, be careful, because whatever you say might be admissible even before it's in the form of a formal statement. I hope that answers the question.
Yeah. So should I then verbalize that I am not giving a formal statement? Should I verbalize that? Should I actually say that?
I think the moment that you feel like the questioning is now becoming extensive or combative, or it takes on the form of cross-examination, or you get to the point of thinking that I've said what I can say now, I'm concerned that if I say more, I might be crossing the line, or making statements while it's not based on my personal observation, it's just something I heard some other stand-by say, or I might be mistaken in my memory, given the adrenaline that's pumping through my veins. At that point, I would say I'm not going to make a formal statement now, or if I'm asked to make a formal statement, or the moment anybody asks me to record anything in writing, I would say that, wait, I want to not now make a formal statement. I want to consult with my attorney first. I want to, just calm down first because I'm experiencing shock. But it's a fine line. If you take that line from the outset, how do you expect the person not to arrest you or to consider you as being the victim? So unfortunately, there's no hard and fast rule. But I would say you definitely want to stop before it becomes combative, before it becomes very detailed, and before you commit anything to writing.
The last question on that. And this is a sign of the times. Whenever something happens, all the phones come out and everybody starts recording.
Yes.
Can it help you or can it count against you? If, let's say, bystanders, your family or whoever stands there and records this whole thing.
Well, I guess it depends what they are recording. What I do find it's quite dynamic. On the one hand, you see instances we recently had an instance where I think a few hijackers were shot next to the highway, next to the N1 or N12, I believe. And there was some video. I didn't see it in detail. I don't even think it was taken by, let's say, the victim who shot the criminals, but by one of his supporters or a stand-by or whatever it is. And now you see, bodies lying around, and it's quite, it makes quite the impression. And depending on what is said or what is overheard or what is seen on this footage, it might make you look really bad, even though 5 seconds ago you were absolutely the victim of an unlawful attack. On the other hand, I do find that once people know they are being filmed, they quite often act more reasonably, and because they understand the implication of the evidence that is now being recorded against them. So it's difficult, and depending on the situation, you wouldn't want people to film or this or that. And it can be very dynamic, especially if it's in a public place and there's, a whole crowd looking at what's happening. I don't think it will be useful in that instance to try and discourage anybody from recording. I would definitely say that the opposite is useful, especially if you consider the facts and let's call it the scene to be beneficial to yourself. You must absolutely try and record it, and you must absolutely try and document it. And that's the next point that I was getting to. Is that you want to point out on the scene, in addition to obviously controlling the narrative, like I mentioned, that is part of that, is that you have to point out to the police or to our witnesses or to whomever, beneficial evidence on the scene. And unfortunately, it happens very often that the police treat crime scenes with absolute disregard, access isn't controlled, and you have people walking all over the place and picking up things and this and that. So it would be useful if circumstances and if the scenario allows for it to, take photographs, take video recordings, but be sure to do it in such a manner that it assists you, as opposed to being used to attribute guilt to your actions 5 minutes earlier, if you know what I mean. All right. And then I think perhaps the last step, and like I said, it's debatable where exactly you're going to do that. It depends on the circumstances, but call a lawyer and have that lawyer advise you going forward. I often find that these things happen, and then you hear from a client for the first time a week or two later. And by that time, statements have been given and this and that has been done. You want to also point the investigating officer in the right direction as soon as possible. And evidence disappears very quickly. So I think it's important to lawyer up as soon as possible. I think it's important to have somebody on standby beforehand, to have contact with the criminal law attorney, somebody you consider to be capable. I don't expect you to go and consult with the person beforehand, but at the very least, have a number for somebody that you can call. And what I ideally do is that when I have these discussions, I give people my number. I say to them, send me a WhatsApp with your name and say that, it's in connection with a possible scenario where I might need legal representation in a hurry. And then I save that person's name on my phone, so that when they phone me at 2 a.m, I know that it's not some spam call or this or that or the following, and you actually pick it up. Because if you have to start scrambling on the scene to try and find an attorney, you're going to end up, it's going to waste time before you get to a attorney, and the chances are 90% that that attorney doesn't practice criminal law, etc. So I think it's better to do that work beforehand. The last important aspect I think that you can list as far as the steps to be taken, even when this scenario is now sorted out, let's say ideally you were not arrested, there needs to be an investigation now where the police detective who is assigned to the case docket, who's called the investigating officer, he now needs to follow up witnesses and get statements from them. And they will obviously, if your firearm is seized, which it likely will be, it will be sent for ballistic testing, and there will be a post-mortem on the deceased, etc. And it's quite important that you, through your attorney preferably, remain in contact with the investigating officer and remain on top as far as is possible. If you are a suspect or an accused, he might very well not want to disclose any information to you before the time that you actually get disclosure of the copies of the police docket prior to going to trial, if the matter develops that far. But you want to try and remain in contact with him. Make sure that he follows up, the eyewitnesses that you want him to speak with. Make sure that you hand over whatever valuable exhibits you might be in possession of. Do not assume that stuff is going to happen in the background. Believe me, it's not. So I think that's more or less the steps. We could, just list them briefly in the comments or something like that. One thing that I might have, should actually have mentioned earlier, and that I can perhaps say at the conclusion, is this investigating officer or a police officer on the scene, because at that point the investigating officer would not have been appointed as yet, or a police officer who is involved in the matter later on in the investigation. He has a certain discretion as to whether he's going to arrest you on the scene or later or not. And that's why all these steps that you take are extremely important in determining what your initial position is going to be. If you are arrested, you're going to have to do a bail application. Depending on the circumstances, that might be an easy hurdle to cross, or it might be very difficult. And from there, regardless of whether you're arrested or not, at some point the docket goes to the prosecutor at court. The prosecutor decides whether or not to prosecute you, and from there a criminal trial process will follow. And I'm not going to go too far into that because there's various different scenarios, but in short, I can say that I've had more instances of, let's call it what we would consider a straightforward defensive shooting. Somebody breaking into your house and assaulting you, or attempting to assault you with a knife or a firearm, or somebody trying to hijack you. Let's make it quite straightforward for purposes of the example. More often than not, those guys are not arrested on the scene, and definitely more often than not, the moment the docket gets to court, the state prosecutor or the public prosecutor declines to prosecute the matter. And that's not quite the end of it. There's some other implications that follow, but rest assured that if it depends a bit on, I guess, on how exactly things play out. Self-defense is not always that clear cut, but if you, I think, follow these steps and you provided, obviously, it was a legitimate defensive shooting, the likelihood is that you are not going to be arrested and spend time in prison before, or in jail before you might get bail, or even advance to the point of a trial. On the other hand, it might be that you need to fight a long battle at the end of the day. So perhaps the very last point that you could add to all these steps is you need to be prepared to deal with the aftermath of what has happened. That will involve trauma. That might need to involve trauma counseling. That might involve an extended criminal matter where you actually get charged, or an inquest where you are called to testify during the inquest. So be prepared that this is going to be quite something if it does occur. And I think that's more or less
I think that's
quite a mouthful, but I think that's more or less what I can tell you as far as the steps to follow. As I said, it would be useful for us to summarize it in the comments or similar, and I'll gladly do that. But I think these are the main considerations that you will be faced with the moment that you've discharged. Not only if you've shot someone in private defense, but let's say you've discharged your firearm, or perhaps even have pointed the firearm. The logic remains the same as to all these steps, that you need to control the narrative and you need to steer the matter without obviously interfering or obstructing justice. You need to steer the matter in the right direction. Do not assume that the powers that be are going to do it on your behalf, because they won't.
I think it's a very important note that you've made, that be prepared for the process or the consequences, and I think that assimilates or counts for any person that does carry a defensive firearm or have a firearm licensed with that purpose in mind. And if it culminates in that it's serious, and you do need a good criminal practitioner on board, irrespective of whether the shooting was outright good or that kind of thing, or whether it was a complex set of circumstances around it. I think guidance in the process, even as a legal practitioner with a pretty good substantive understanding of criminal law myself, I think in the process you need that reassurance, or that objective calm mind and that objective learned mind to guide you in the process. Not necessarily in the substantive aspect of it, like you say, it might be a very clear, good shoot. But in the circumstances, I think that you should always be guided. And I think what it costs you in having the attorney assist you with a statement will play a very big role in what it costs you in defending the matter, potentially moving forward, and in the long run. A poor statement was a poor admission in a statement, or an allegation in a statement could cause a lot of trouble on a technical aspect moving forward, and it takes a lot of work to explain it away. So rather do it right at the commencement or the initiation of the issue than at a later stage, saying, look, I think this is what I said to them on the scene. I don't know. Take control of the scene. Don't make admissions. If they ask you simple things like, did you shoot him? Yes, I was the victim of an attack. I had to use my firearm. Just again, the psychology is, and Francois, I think you were very clear about it. But the purpose, or in the back of your mind, when SAPS gets there or they start looking into it, the whole purpose is that I used my firearm to stop or repel an unlawful attack. I didn't shoot to kill. I didn't shoot to it wasn't, the wording is always that I stopped the attack. I was being attacked. It was an unlawful attack. I don't know who this man is. He's an intruder. He was in my house. He's armed, or, it was dark. He started moving towards me after I told him to stop. These are things, again, where it plays a very big role, even if the guy is unarmed. There are certain circumstances, and this is, we'll get into the academia behind it at a later stage. But there are certain circumstances where your wording will dictate whether your action or your conduct was right. So I think that's just very important, is always to keep in the back of your mind that the self-defense or private defense as a defense in our law is that it was an unlawful attack that was stopped using potentially lethal force, using the firearm, which is, lawfully licensed to, and that's a lawful purpose to stop an unlawful and, potentially deadly attack. So Francois, I think, that for me is always in the background. I think we'll get into the academia behind the defenses into the next part of the series. But, the entire thing is I was a victim of an unlawful attack, and that I've lawfully used my firearm. It's a licensed firearm. Those are the kind of power words that we'd be using in the statements.
Yeah.
And I take it that this will count for whatever means of self-defense I use. So if I took a chair and I killed somebody with that, it will be the same thing. This is not just about a firearm.
I almost want to, I think we've lost Max for a moment. Dion, I almost want to say that it applies to any scenario where, let's say, police arrive and or there's a crowd, or whoever it might be, and you need to control the narrative and try and influence the direction in which this thing goes. Whether it's people having a disagreement regarding a parking space that escalates, or whether it's, as you say, a defensive shooting. I think these steps there might be certain instances where you approach it differently, but I think this is solid advice as far as how to deal with any of these scenarios, whether it be during or after.
Yes, yes. So what we're going to do is we will obviously give out Francois' number for you guys. Please don't send him WhatsApps or phone calls and ask him, but what about this and what about that? Then it becomes legal advice, and he will then send you an invoice for that. So please don't do that.
Yeah.
Please just send him.
Max is the one who likes that and who does it for free. So please,
I know
any
Max
questions?
gives out advice for free, so send Max. But for Francois, you just send him a WhatsApp and tell him that you've seen him on the Fortis chat, and you must just save your number in case you might need to phone him in an emergency. Then he's got your number. But please, if you want to ask him for any advice, set up an appointment with him and go through the formal structures, the same as with Max. The guys are professional, so obviously you can't just phone them, and please don't sell them any network marketing scheme after hours. Don't add them to your mailing lists. I'm just saying, there might be people who go, yeah, well, you know what, I'm going to invite you to this meeting. And then there's something else going on.
Yes.
No, thank you. And again, thank you for your valued input. I've consulted with you a few times regarding hypothetical scenarios and real scenarios for clients, and you've done exceptional work so far. And yeah, I think it's really good for Fortis to have your type of expertise, speaking frankly about these considerations and out of experience. And yeah, guys, I'm looking forward to the next one.
Yeah, well, I share the sentiments as far as your own skills and abilities and contributions are concerned, Max. And Dion, thanks very much for creating that platform. And thanks for having me. And I look forward to joining you guys again in future.